right, briefs and everything. This is the matter of Coombs versus County of Monmouth, Marion Masnick, and the Monmouth County Prosecutor's Office, MONL 319-518. Your appearance is for the record.
Good afternoon, Your Honor. Walter Lors appearing for the plaintiffs on this rainy and windy afternoon.
Good afternoon, Judge. Sean Keene, Cleary Jacobi, Cleary and Jacobs, representing Monmouth County.
Gentlemen, how are you? You can be seated. Good. Okay, and so do we all know that you have to turn on your electronic devices? Okay. Alrighty. So, gentlemen, I have had a chance to read, thank you, Kim, read the papers and the law in the area. And so what I'd like to do, Ian, could you turn that down a little bit? I hear it coming back at me. What I usually like to do is tell you what my concerns. I hear it. Do you have headphones?
Yes. You have headphones? Yes.
I hear you, like they can hear you too.
I hear you, like they can hear you too.
It's that 2 seconds.
Oh, yeah. How about now?
I'm trying to get one.
Oh.
You're What I usually like to do is, oh yeah, I can't, it's driving me bonkers. Need me to call to get you help from someone?
I'm trying to get where I know they have voice recorder. Anything I could.
How about you go off the record, Ian?
Yes.
Let's see. Tell me when you're on.
I'm on, it's on.
Okay, so if you're on, what?
No.
Oh gosh, no.
Because I want to hear.
All right, so put that into here. You got the headphone jack in here.
Okay. Yes.
Working now?
Yes, I can hear.
Okay, and we can't hear, and you're on.
Right.
Okay, so we're good. Okay, Jeff. So what I was going to say is a lot of times, I like to give you what my thoughts are, so you can address the issues of concern, and then, of course, you're not precluded from putting whatever else it is that you want in your argument. So I'll tell you, in this particular case, Mr. Kane, I have more concerns with the defendant's case, okay? So let me tell you what some of my concerns are. I'm going to let Mr. Loris talk, and then you can be framing what some of your arguments are. So the first one is regarding the statutory requirements of how a request is submitted, right? So according to the statute, what does one have to submit for it to be a valid records request? And I don't think there's anything that's in the statute or any of the case law that says that if someone properly makes a request, that a defendant can impose additional measures to process that request. And if in fact, because the defendant spent a lot of time in the brief talking about privacy concerns, in this particular case, I don't think the ask was give me private information. If a determination is made that information requested is private, it should be denied based on the privacy concerns, right? And in this particular case, what appears to have happened based on both the reply brief from the plaintiff and the defendant's reply is that the defendant had a bad experience at one time where someone pulled together a records request and disclosed a confidential information. And as a result of that bad experience, the way the defendants have chosen to deal with that is to adopt this policy by where they won't respond to an Oprah machine, right? An organization like Oprah machine. Where my concern or my question or my thought is that shouldn't the remedy be let's put in some measures on the part of government bodies, and I think Oprah kind of has dealt with that in some way, to make sure that the person who made a mistake or wasn't as diligent, recognizing that, right, nobody's perfect, court's not perfect, court staff aren't perfect. Nobody's perfect. I recognize the responsibility of any public agency and a custodian, but shouldn't the remedy or the measures be imposed on the government agency, the custodian? Listen, what you did was wrong, or you can't do that again, heaven forbid. You know, in the future you need to do this, 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 and this. By way of example, the judiciary is not subject to Oprah, but we're subject to 138. And you can imagine, we get a lot of records requests. We get a lot of media records requests. To be honest with you, sometimes our partners in the media and also private citizens get a little salty with a decision that I've made with respect to responding to records requests. I put in place a system that says that no records request is going to be almost no records request is going to be released unless my eyeballs or the presiding judge's eyeballs have looked at it. Here's why. As we have had these conversations, probably with both of you gentlemen in other cases, I recognize that whether you're dealing with 138 or Oprah or the common law, the three of us are attorneys, and you all just didn't pop up and come into court and argue. You had to do research, you had to look at the issue, so on and so forth. And most custodians are lay people, even though they've been doing it for a long time. So I recognize that when you're dealing with something that is not necessarily easy, black and white, it takes a little work, right? And I think that's why the legislature put in place these measures giving the custodian a right to ask for an extension, right? It's a little complicated. I need an extension. I didn't see anywhere in the defendant's papers that said, well, yeah, this was the mistake and this is what we did. We told the custodians, you got to do A, B, C, and D. It appears that in reaction to that, and maybe they did, it just wasn't present in the papers. The reaction was to do this. And in addition, let's just assume that I said that this was a valid policy, and the custodian makes another mistake, and the custodian sends the records to Ms. Coombs or Mr. Epstein or Mr. Razi, and at their own email address, right? And it only takes a matter of minutes, I would imagine, when they get those records requests, where a custodian may have made a mistake and put confidential information in it, for them to upload it on Facebook, on Oprah Machine, or any other mechanism. So the county's policy really doesn't protect them against their concern. So those are some of my thoughts. And also, let me see. I perused this executive office of the president, this OMB memo, and I don't think that anything is in here that says that you shouldn't use a third party. But more importantly, I think this OMB memo is designed to give guidance to federal agencies when they partner with a third party, because that exists, right? There's companies out there that come to the federal agencies and say, listen, we're going to make your life easier, and you can contract with us to process your records request, right? What also exists in the federal context are companies, websites, whatever you want to call them, that are like Oprah Machine, right? That are a warehouse, if you will, for FOIA requests, right? And I think that in many ways, Oprah Machine does a service for custodians, because I went to look at the website myself, and some of the records requests. And if people are familiar with a website like this, or, oftentimes a custodian may get 5 different requests on the same thing. If somebody is familiar with a site, whether it be in the state or federal context, and I want something, if I go on their website and I see it's there, I don't have to bother the custodian now and make that 5th or 10th or 20th request for records. And now that custodian can spend their time maybe putting more time into reviewing those records. Going back to the point that I said here with the 138, I say one of us has to look at it, because I don't want something going out of this building that is precluded from public access if I'm not confident that I've looked at it, because when I get one, I have to go through 138. 138 is big, right? It's got all these different subparts, and I have to look at the record and analyze it in terms of, is this covered by this, right? So I get that they have a lot of work to do. Sometimes they may not necessarily be steeped in all the law, and I think that a website like this really, I think if people. I think the gut reaction sometimes is when you're dealing with a different set of players, and the gut reaction is that it's bad, and sometimes I think we have to take the focus off the player and what the statute says in the common law. Like we have ones here in I say, let's just focus on, is the document, forget about who requested it, forget about this, forget about what your visceral reaction is the document covered under 138, is it excluded or not? Because if it is, we ought not, be involved and worry about what this person said or what that person asked us. Okay, so Mr. Lures, with that said, the ball's in your court.
Yes, Your Honor, thank you, and I'll walk through the issues that Your Honor identified, and I don't intend to repeat what was in my papers because I know Your Honor is familiar with the papers from all the attorneys. So, in terms of the O&D memo and the federal authorities cited by the defendant, I didn't find them terribly applicable to this case because we already have OBRA and we have a structure in place. And we are seeing more and more that I know, what I've been told is that the New Jersey Department of Environmental Protection gets the most OBRA requests of any agency, thousands per month. So they have a database where if you go to the DEP and you say, I want to make an OBRA request, they say, well, before you make your OBRA request, look at our massive database. Probably a little redundant. They call it data mining or words to that effect. And so, yes, as the state and hopefully cities and counties become more sophisticated and as requesters become more sophisticated, you'll see the data and the documents available in databases. So like for salary, we're already there. If you want to see someone's salary and they're a public employee, you just look it up. And why is that being done? Well, it's being done in part for transparency. It's also being done in part to reduce the burdens on records custodians because, yes, as more people become aware of OPRA over the years, and as the sheer number of records just grow and grow, custodians are going to have to do a lot of work. And I think that's easy to acknowledge, that OPRA custodians, especially counties and municipal clerks where maybe they don't have a tremendous amount of support or the relative amount of support that's available at the state, I think that these data warehouses and OPRA machine, I think they're a net benefit. Especially, I think you're exactly right, Judge, because I think there's an art to making an OPRA request, and a lot of people, a lot of laypersons, not everyone can be attorneys, a lot of laypersons, they don't know how to make good OPRA requests, but maybe they go on OPRA machine, they see how the experienced people, especially like the plaintiffs here, because there's, what we might call frequent flyers. Mr. Epstein, Mr. Rossi, and Ms. Coombs, who's here in the gallery with us today.
Ms. Coombs, would you like to come sit at council table?
Thank you, Judge. Appreciate it. So,
now you got to turn your iPad off, right? All right.
Thank you, Judge.
You can have a seat, ma'am.
So I agree with Your Honor's observation that OPRA machine is a net benefit, and that maybe folks' first stop will be to places like OPRA machine before they send off an OPRA request, where they just ask for any and all records regarding X, Y, and Z. Maybe they make a more focused OPRA request, or maybe the information they want is already on OPRA machine. You talked about what I would call an inadvertent disclosure of private records. Judge, I'd like to think that an OPRA machine, both in general and in this case, is a good citizen. OPRA machine has a notice and takedown policy. Now, the notice and takedown policy, that's something they do for copyright, but they also do it for Oprah. So let's say you put up, copyright is, let's say you put up something that someone else claims a copyright. So they send you an email or a letter, they provide you notice, you have to take it down unless you can show that you're allowed to keep it up on the internet. But Mr. Rossi, and it's all in the record, Mr. Rossi does the same thing for Oprah requests. And so actually it was another Monmouth County request where I think Ms. Coombs submitted a different Oprah request. I forget whether Ms. Coombs submitted it or it was about Ms. Coombs. I think it was about Ms. Coombs, where some of Ms. Coombs' information actually hit the internet, and Monmouth County requested that the information be taken down, and it was taken down in 24 hours. And that's the only example we have of an inadvertent disclosure. When there was an inadvertent disclosure, the information was taken down by Mr. Rossi and Mr. Epstein are the ones who run Oprah Machine, mostly Mr. Rossi, somewhat Mr. Epstein. Then the only other example of an inadvertent disclosure was where Mr. Paff, who I'm sure is a name you recognize, he made an independent, not connected to this litigation, he made an Oprah request for attorney invoices, and there were 2 names referenced in the invoices, and the attorney for the county said, well, can you redact the names? Well, and he said, well, can you redact the name? Mr. Paff said there's 2 names, and I don't, as of the time we filed a reply, they had not connected. But the point is that folks are being responsible citizens. I think that if you were dealing with sensitive records and folks are being irresponsible, that would lead to a different result. But I think in the context of this case, when Oprah Machine has a notice to take down policy, they follow it, they do the right thing. And also, in terms of the inadvertent disclosure, in this case we only have these 2 instances. And I think it gets even better for us because the types of records we're requesting are not records that are private. We're requesting attorney invoices and settlement agreements and grants and similar types of records. We don't have to go through every single type of record that's being requested, but these are not the types of records that generally you have risk. I would be very surprised if Social Security numbers or anything like that would come up. So I do think that, as Your Honor said, it is and just sort of moving back through your concerns, it is the responsibility of the records custodian to withhold records or redact them and put in place whatever checks are necessary. I think if you notice here, the Oprah requests were being processed by Ms. Kim of the defendant's law firm. I believe she's an associate in the law firm representing the defendants. So it's clear that the defendants have already elevated at least part of the responsibility for responding to Oprah requests to counsel, which unfortunately as Oprah requests become more sophisticated, bless you, Your Honor, there will be some Oprah requests that require in-house counsel or outside counsel to look at that. And that's part of being a records custodian. Your layperson records custodian is going to have to ask, or at least know when to ask for help. And it sounds like that's already happened here. Just pre-litigation back in when these requests were being made, and I think for June, July, August, outside counsel was already involved. So clearly, internally, they had already reached the point where they felt that it was appropriate for outside counsel to handle the requests. And just sort of, again, sort of completing the track in
Excuse me.
Bless Your Honor. You asked the question, well, what's a valid Oprah request? Well, sure. A valid Oprah request is in writing, transmitted to the agency, and it says Oprah. You have to invoke Oprah. If you don't use the words Oprah, then it's just a request under the common law. So it has to be in writing. It has to say Oprah. It has to provide a way of contact. You, as the requester, you have to provide a way of being contacted. And the case, and I don't remember if we cited it in our papers, but it's Renna versus County of Union. That was the one where the County of Union said, well, wait a second, you're giving us an Oprah request, you have to use your official form. you have to use our official form. And the appellate division said no, even though public agencies are required to have a form, requesters are not required to use it as long as they provide sufficient information that they're utilizing Oprah and they have sufficient contact information and they give a way for folks, for public agencies to contact them. So in terms of what is a valid Oprah request, I would rely on Rena versus County of Union. That's in terms of Oprah, it's a little bit of an older case. I think that goes back to 2010. But it's published appellate division decision. So, Judge, I think here we have a proper Oprah requests. They were submitted to Monmouth County. I don't think there's any dispute that they were received because, as you saw, there was a back and forth. And I think that Oprah allows records custodians the right to ask for extensions. It's developing to be the practice in the state that if you need an extension of 30 days, it's not a problem. If you need an extension, out to 45 days, maybe 60 days, again, the practice, and in terms of what the courts have said informally and informally, not too much of a problem. It's only when you get out to like 90 days, 100 days that you might start to have problems. But if records custodians need time to sift through maybe sensitive information or make the appropriate redactions, and we haven't even gotten that far in this case because we don't even have anyone saying that, hey, these records are sensitive. But if there was a request for sensitive records, then I think that records custodians should be allowed the appropriate amount of time. And whatever level, I mean, you said here, within the courthouse here, you have a 2-level review. Maybe it sounds like there's a staff level, and then it gets elevated to you.
They pull them together, right? So the staff pulls them together.
Right.
Initially, I wanted to look at them, and now I've gotten a little bit more comfortable. As long as the PJ in whatever respective division looks at them. But they're all sent to me.
Right. So here you have at least 2 or 3 sets of eyes looking at documents. And that for a sensitive record, if it's your run-of-the-mill document, 1 set of eyes. But if it's potentially sensitive, multiple sets of eyes and maybe an attorney review, and that's just what the law requires. So, unless Your Honor has any questions, I think that what I would ask for the court today is a holding that there's nothing wrong with requesting records through Oprah machine, and an ordering the records that are requested to be produced. And again,
so you may not get that today.
Well, one of the things lawyers tell us is that lawyers and judges tell us we should always be clear about what we want.
You're very right.
Lawyers are not always clear
You're very
about
right.
what we want. So my goal is the relief we seek is a finding that an Oprah request from Oprah machine should be treated as any other request, and an order that the records should be disclosed. And of course, if there happens to be a social security number or some type of private email address, then I always work with people. So if there's a document that needs to be redacted or whatever, we never try to give folks a hard time about that because the law does allow for redaction.
Right. So just so you're clear, without saying how I'm going to decide, let's just assume I decide in the plaintiff's favor. The relief wouldn't be exactly like, it's not necessarily about Oprah machine, but about the facts of this case, right? So I wouldn't give like a carte blanche on Oprah machine, because I don't know what Oprah machine means, but it would be on the facts. Now, if somebody interprets that to say, well, that's fine. If you're following me.
Yeah, because the very recent cases say that, well, Oprah is about getting access to records, not about getting declarations that something is. Or something. That's what the very recent cases say, and I abide by that.
Okay.
So yes,
Okay.
So the specific relief would be provide the records.
Yep, I got you.
Thank you.
Mr. King?
Thank you, Judge. I'll give it my
Mr.
best.
King, can I ask you a question?
Sure.
Kane or Keen?
Keen.
Keen, okay, I'm glad I asked.
I want to apologize. I was down with Judge O'Brien on a Cullen matter for one of our towns.
No, that's important.
That's why I
No
was a few
worries.
minutes late.
No worries.
I apologize. But,
No worries.
Just to start out, if I might, Judge, with just a few, I'm not going to certainly go through our brief, but just to point out the obvious, in 2014, the U.S. Department of Justice reported that 17 million people in the country had suffered some type of identity theft. That's 7% of Americans over the age of 16. This case came about, the facts of this case, because there was a mistake or an error made at the county where certain sensitive information of certain high-profile individuals in the county were released out into the stream of commerce or stream of corruption, whichever stream you may choose. In this particular case, the Oprah machine, I take my hat off to them. They're a responsible corporate citizen. They did the right thing. The county called them and said, would you do the right thing and please take this stuff down because it wasn't supposed to be put out there, and they did it immediately. They did the right thing. But Judge, we asked the court, what happens next week when the three amigos who were convicted in a Sandy fraud, and this is hypothetical, in some type of a nefarious scheme, when they get together and said, we want to get together and put together some kind of a website because one of us has some technological expertise and we think we can make money putting this stuff out there. We can make even more money if we are the beneficiary of some future mistake.
How does this policy prevent identity theft?
This policy would give us the opportunity to turn around, say to Ms. Coombs or somebody else who we provide the information to, and say, hey, gee whiz, we just screwed up. Yesterday we released the Social Security numbers, and would you please do the right thing and not send them out? And if you send them out, there may be some repercussions for you. I don't know. But if that person, sorry.
I'm sorry, Mr. King. So what, the next day, here's my question, because we know when we look at, for example, the law in the area of like the Open Public Meetings Act, right, and that folks' right to access, whether it be their right to speak or the right to records, is not unfettered, but those limitations should be narrowly tailored, right? So what is that step that has occurred from Tuesday when the records that were released to Wednesday when somebody finds out that, I think, did you say in this case the county council went, or in the other case the county council went to look at it and realized that this person had released some documents that they shouldn't have?
In both cases, attorneys representing the county, luckily it was not our firm, but attorneys representing the county in some fashion, released the records mistakenly, and then after the fact went and made efforts to, in the first case, Ms. Coombs' case, to get those records taken off the internet, taken out of the web. And they were successful. They had cooperation. So
the attorney that released them realized their mistake the next day?
I believe it was the next day or the day after.
Okay. So what happens using those same facts? Because my question would be, well, maybe that attorney's got to do the little two-step like I do here. And what happens when, same facts, Ms. Coombs says, here's my email address, jcoombs@aol.com, and the lawyer or the custodian emails her the record. Ms. Coombs gets them and she uploads them immediately to Oprah machine, or she puts them on her Facebook. The county's policy is not going to prevent that from happening.
Judge, first of all, in that case, therefore, the county would not be responsible for those items being put on the World Wide Web if they, in fact, got to Mrs. Coombs before she did that.
How come? Because somebody dropped the ball at the county.
But they tried to correct it.
But they didn't at this point, right? Because there's nothing in the statute or the case law that says once somebody gets these documents that when they ask for them, they are presumably public, that says that they have to hold on to them for a certain period of time, right? There's no authority that we have that says, oh, you got the public documents, you can't share them, there's nothing that says you can't share them with anybody, you can't hold them, or you have to hold them for a certain period of time. And the only authority that I have that says that if they want to go out on Monument Park and show them to everybody, that is their right. So I'd have to say it is And Lord knows I got enough dirty laundry in my own basket, so I don't like to say anybody it's wrong. But it is the responsibility of that custodian that inadvertently released that. And so those two examples, the same thing's going to happen, and this policy is not going to prevent, I said, you know what, your policy is right, and somebody is not as clean in their review, they send it to Ms. Coombs' email address, she puts it up immediately on Facebook. That policy did nothing to address what your privacy concern was.
Except, Judge, that we could then ask Mrs. Coombs to take it down, and if she said no, I could come in here before Your Honor and ask Your Honor to force her to take it down.
You can still do that.
Social Security numbers.
You can still do that with the Oprah machine.
And again, counsel kept mentioning the kind of integrity and the way that his client operates the Oprah machine, and we agree, they acted properly. One of our fears is in the future that one of these entities does not do that, and they don't cooperate with us. So, backing up a little bit, Judge, because I did hear you talk about the amount of resources that government needs to spend on these items. You know, the county has to go through hundreds of pages of these requests per month, and we know whether it's a town or a county or a state government. I would hate to use the DEP defending a position, because the DEP is a complete nightmare. You wait months and months when you ask for a request to the DEP. But notwithstanding, the county has already expended considerable resources in attempting to address this. It is now the situation where most, if not all, of the OPRs are being reviewed by attorneys. But attorneys being humans, there is going to be error. I guess that there is some way and some future date, after spending millions and millions of more dollars of the county taxpayers' dollars, we could try to put together some DEP data bank where everything in that data bank is current and is redacted. But I think, and counsel, I don't want to put words in your mouth, but I think the DEP data bank is something where, you know, every file between 1995 and 2005 is in that data bank. You can't get current vouchers. You can't get all those items that you're eligible to get within 7 days. All that requires human beings to look at this stuff.
Yeah.
Human beings are going to make mistakes.
I absolutely hear you. I mean, maybe the remedy is the legislature.
I agree.
The legislature,
It's a case of first impression. There's nothing in the statute that says broadcasting it to the universe by via the web is something that the statute contemplates. I think it would be reasonable for the court to say, well, wait a minute, no. If somebody wants to make an open request, it can be, they have to provide a specific email address. Now, if that person gets it, and they go do whatever they want with it, there's no question about that.
Your same concern is there, though. It doesn't prevent, your policy does not prevent a situation happening when you give it to her and she uploads it on Facebook.
No policy is foolproof. It's not going to prevent it, Judge, but no human being...
I don't see how it helps it that much.
It does help. I definitely think
How?
it helps.
She gets it and she says, I want to put, the public has a right to know. She gets the same, and I'm familiar with the case that you're talking about. You know, I don't see at all how it helps. Now, you stop me and try to walk me through how it helps. Same situation. You say, okay, we got the information for you, Ms. Coombs. We're going to send it to you. And Ms. Coombs, whether it be through Oprah Machine or Ms. Coombs, she's on Facebook. No, Ms. Coombs? She's out there. She's on Facebook. There is nothing to prevent her, and she puts things up on Facebook quickly, don't you, Ms. Coombs?
For the most part.
Yeah, she does it quickly. There is nothing to prevent her from going, and when she gets that email, and I'm not a big Facebook person. I'm scared of Facebook, to be very honest with you. That's why I don't have any friends. I'm scared of it. I would imagine, though, can you go when you get an email? Can you go upload it? Can you put it right on Facebook, Cody?
Oh, yeah.
Nothing will preclude her when she gets that. She establishes her own Oprah machine, right? She could establish her own Oprah machine through her Facebook page. And when she gets that email, she puts it immediately up. And if somebody wasn't as careful, that same information is going to be there. And the issue, I think, is the privacy concern of the individual, which is a very valid point. But I think that it has to be corrected more on the defendant's end. And this particular, I'm having a hard time, and I'm always open, to listen. I'm having a hard time figuring out how this policy really addresses that your valid concern that folks, their private information is being up on the internet because the custodian or attorney inadvertently released it. I don't want my personal business. I don't like the fact that people can go online and see where I live, right? I don't like it, right? This is a whole lot of stuff I don't like that's up there.
No, just to reiterate, I'll make it brief because we're not on the same page, but it would be helpful in the county. It would not stop in all cases somebody from, like Mrs. Coombs, putting on Facebook and then saying to the county, I'm not taking it down, go pound salt. You're right, Judge. The policy would not, in every case, prevent something like that. However, in a lot of the cases, it might, where we know that it's not Mrs. Coombs, but it's Joe Jones over here, and we call him up and he says, gee whiz, I don't want to do something to hurt so-and-so, so I'll take it down right away. We wouldn't have that option if it went directly to Oprah Machine, and Oprah Machine, or whomever the entity is not as good a civic citizen as the Oprah Machine is. It's somebody else, somebody nefarious, who doesn't agree to take it down. Then where are we, Judge? And then trying to figure out who the corporate owner is, this entity that you probably can't even figure out who owns it. It would be more difficult to...
Why is that important?
No, I'm not saying that part of it is important. I don't care whether it's Mrs. Coombs or anybody else. We look at these issues, Judge, and we treat everybody the same way. My point is, if we have a cooperative Oprah Machine, then we can really kind of get rehabilitated from the error that was made. Because they see the error. They don't want so-and-so's social security number out there. They know that should have been redacted. They know that that's really superfluous. It's not important. But if somebody else who may be involved in identity theft using people's social security numbers or credit card accounts, which were part of this case, bad stuff, Judge.
I think it may be helpful under the following circumstances. If Lisa Thornton makes an Oprah request and you send it to Lisa Thornton's email, she's not really that savvy. So I don't even know how to upload it immediately on Facebook. The problem is, from your perspective, you don't know who is or who is not. You don't know who's savvy and who's not. In that respect. With Ms. Coombs, if she's just, say if I rule against the plaintiffs here, and Ms. Coombs, and a lot of people, Mr. Paff, almost in real time, goes and starts blogging on stuff immediately after the court proceeding, right? So this policy does nothing really to prevent this evil that you're concerned about, unless maybe somebody is not quite savvy social media or computer, I think.
Could I touch on a couple other items, Judge?
I would be disappointed if you didn't.
Thank you. Just in terms of the time within which the lawsuit was filed, it's our position, and it's in our brief, that it was outside of the 45 days to answer. Prerogative writ, which is the 45-day window. And Judge, at a minimum, whether the court rules that that's the case for the 5 Coombses matters, at a minimum, the 2 remaining cases with Rozzi and Epstein should be dismissed, Judge,
okay.
Because...
Let's talk about those dates. Walk me through those dates.
I believe the alleged denial of the request took place on July 19th, and this complaint was filed on October 4th.
You mean September?
I'm sorry, September. You are correct.
And so the point that, so they're all around the same time, right? The denials and the requests. Yeah, the point that Mr. Loris makes is let me pull out the rule again, 1-3 something?
1:3-1, Judge?
Yes. Says that because it's a weekend or a holiday, it can be filed the next business day, and it's undisputed that he did file it the next business day. When the legislature has not said it has to be regular days, not business days, and the 45-day period, I don't think it's in the Regular days is not in the statute, is it?
It's it's the same time, it's the same time as the prerogative right.
Correct.
Yeah, that's in the court rules.
It
doesn't come from the statute.
45 days.
It doesn't come from the statute. How about this OMB memo, Mr. King?
Judge, OMB memo with respect to the privacy issues?
Yeah, there's nothing in this. I think the OMB memo contemplates federal agencies that utilize these third parties to handle their OPA requests or to engage them in a public way, not necessarily responding. And even if you assume that it did, there's nothing in here that says that you shouldn't use them.
We were raising that, Judge, to point out the resources and efforts that have been made at the federal government to deal with breaches. And there's a breach. This would be considered a breach under the Federal Freedom of Information Act. And when there's a breach at the federal level, Judge, they have computer systems in place, and they have a protocol as to what should be followed. And the software alone that is used is in the millions and millions of dollars. And the reason for that is because the federal law requires that certain things be done when there is a breach. We don't have those types of requirements, and if we did, we'd be millions and millions of dollars more in the hole in the county than we are now. We don't have those systems in place. We just wanted to point out, Judge, that we're really comparing trying to require the county of Monmouth to comport with what is happening at the federal level. It's just apples and oranges, and the resources just aren't there, Judge. That was
I didn't see that Mr. Lord said that, although the case law tells us in certain circumstances we can or should look to federal jurisprudence. But I don't really think you needed to look to federal jurisprudence on this particular issue.
Can I mention a couple of items, Judge?
Please.
With regard to the Rossi and Epstein matters, I know you heard me with regard to the 5 Coombs matters in the 45 days.
Mm-hmm.
The Rossi and Epstein matters, there was an initial communication to the county, and they were informed on July 18th or 19th, I think it was the 18th, and that we had this new policy, and we just never heard from them again, Judge. And, under Mason versus City of Hoboken, the court said that the statute should foster cooperation among requesters and agencies. And Mr. Lewis is the best model of that. Somebody who practices very responsibly. He'll call you up on the phone, he'll email you, he'll say, can you guys get me that? Well, if you can't get me that, get me that. So I don't have to file another OPA request. We just didn't hear from these folks, Judge. We just assumed that they thought that our policy was reasonable, and they never came back to us and said, hey, gee whiz, that's not reasonable, that's not something that comports with the statute. So we believe in those isolated 2 cases at a minimum should be dismissed just because they didn't follow the dictates of the Mason court and engage in some type of cooperation among the requesting
Okay,
agencies.
so let's pull out Rossi. Let me look for Mr. Lord's certification.
Apologize to interrupt, Judge. So you're going to look for my certification, and Rossi is Exhibit F.
I'll find it. I'm just looking for the date of the request, and if you find it before I get to it, you can tell me. So Rossi, he made the request, what date?
July 13th, 2018, Judge.
Mm-hmm. And how about Epstein?
Also July 13th, 2018.
Okay. And when was it Ms. Kim reply that the county has a new policy?
July 18th, 2018.
Correct.
Okay. So, and she says, we have a new policy, and what? You need to follow that policy?
Good morning, Mr. Rossi. Please be advised that this office represents the County of Monmouth in the above referenced matter. Attached here, too, is a statement regarding the new county OPA policy that modifies the processing mechanism for certain OPA requests. Please review carefully and return the filled-out statement. Once I am in receipt of the statement, the county will proceed with processing your OPA request. Should you have any questions or concerns, please do not hesitate to contact me. Catherine, thank you for your cooperation. Catherine Quinn, Esquire. The judge, after that email, we were never contacted.
Okay, so Mr. Lawrence points to Renner, I believe, for the proposition that says either you're going to give me the records, you're going to ask for an extension, or you're going to deny it, right? Now, this was not a grant. It wasn't a request for an extension, and it wasn't a verbal denial or written denial, but the case law says that if you don't respond, isn't that deemed denied after a certain period of time? They didn't give them the records.
Judge, we just assumed that it expired. They never got back with us. We assumed that they just weren't interested in the documents. They emailed us a request, and they never responded. At a minimum, they should have responded. So we take issue with this policy, or that, what do you need from us, or what's the new policy consist of?
Refresh my recollection. The 45 days runs from what?
Date of denial. And if it's a deemed denial, then it's 45 days after 7 business days.
And so the question is whether or not that 7/18 response should be a deemed denial, no?
It doesn't matter. It's within. I don't want to interrupt Mr. Keene. May I?
You're very,
For me,
very
Judge,
polite. You're very polite.
Sorry.
Who do you want to hear from, Judge?
I don't know. Anything else you want to?
Yes.
Okay, Ms. King.
The judge, in addition to the position I'm taking on the...
On that issue, though. On that issue.
Oh, on that issue?
Mhm.
No, thank you, no.
Okay.
But I'd like to be heard on some other issues.
Of
You want me
course.
to continue or come back? Just
Nope, you
briefly.
can
I just have
continue.
a couple of brief.
Mhm.
And then, Judge, something that we did not raise in our brief, but it did come up. As you know, Judge, the request form, and certainly pursuant to the Rena case, does not have to have
Excuse me.
certain, everything included in the criteria of the document. We just have to ask for the records. However, as we know, under the statute, there is a question that's included asking whether or not you've been convicted of a crime, the person making the request. In those types of sensitive cases where we have somebody who could be a criminal, somebody who could have perpetrated an act of violence against somebody, somebody who could be a defrauder, that would set off a light bulb in the custodian or the attorney who's reviewing that. Yes, I did. I was convicted of theft or fraud or assault. And then they may turn around and say, well, gee whiz, we have to really look at this request closer, because that would heighten our review of the open request.
Let's look at that, because I looked at this before, and I think, and I could be wrong, let's go look at the statute where it mentions that. I think it's when you're making a request for some victim's records, not just that, because people that have been convicted of a crime, I think, can ask for whatever they want. It's when the specific records requested are crime victims' records, and I don't know that these are any crime. But let's go look at the statute. Let me see. Okay. Whoever gets it before me, say amen. Oh, it's in definitions, 47, 1A, dash 1.1. The definition of what is a government record. And it says these records are not government records. Victims' records, except that a victim of a crime shall have access to the victim's own records. Any written request by a crime victim oh, no, maybe that's not it. No, that's not it.
Judge, NJSA 47 1A-2.2.
Okay.
Access to certain information by
1A
convict
2.2.
prohibited.
Hold on 1 second. Ah, yep.
So
Okay.
go to 2.2A. And so what's prohibited is no person convicted of an indictable offense
Mhm.
may access government records containing personal information
Mhm.
pertaining to the person's victim or the
Mhm.
victim's family,
Mhm.
including but not limited to the victim's home address,
Mhm.
home telephone number,
Mhm.
work or school address, work telephone number, social security account number, medical history, or any other identifying
Mhm.
information.
Mhm.
And what's interesting about that is, and I hope you don't mind if I sit,
Mhm.
what's interesting about 2.2 is that most of the information listed in there is already confidential, but the important thing is you can't, what the law prohibits is a convict trying to get the home address
Yep.
of a victim or victim's family.
Mhm. And that would presume that the type of records requested were records that contained, victims. So I don't think that anybody that makes a request has to say whether or not they're convicted of a
What
crime.
what happened was the Government Records Council put out an official form, and it contained a certification, I've never been convicted of a crime.
Mhm.
And that certification is sort of percolated into some other forms, but really, it's not necessary for a requester to make that affirmation or certification. It can come into play,
It should be for a specific type of record request.
Yes.
So Judge, then it would stand to reason that if it was a specific type of record request, we could then deny it based on those facts?
I think so. I think that the statute contemplates that. The statute contemplates if, I'm trying to think of, and I would agree with Mr. Lors, because it says that victims' records, but I looked at what victims' records were, and they relate to like VCC-B or VCC-A, those types of records. But I don't know if there's some records regarding a criminal investigation. The person's pled guilty. The prosecutor's office has determined that there's no criminal investigatory record exemption or something like that. And they release stuff. Somebody's on notice. I got to protect the victim. The victim's name and address are here. And it is very, according to the statute, very appropriate for somebody to say, regardless of who, if I make the request. What I think that maybe the legislature needs to close the loop on that is, if it's saying that if I make the request, nothing precludes me from handing that over to the person that is seeking, right? I always hate to open up my fat trap and get in somebody else's business, but maybe they should just close that whole loop that use victims' records and address, and nobody gets it.
Thank you, Judge.
Anything else, gentlemen?
Judge, very briefly, because I heard a few new things, some issues that you and I didn't discuss. In terms of the Raji and Epstein July 13th requests and the July 18th responses, the county's response was submit us an Oprah report. We're not going to respond to you because you're using a machine. Give us a different email address and send us a new Oprah request, and then we'll respond. So I treated that as the denial.
Okay.
And I think when someone says to you, we're not going to respond to you at the email address you gave us because it's an Oprah machine domain, that is a denial. So I'm very comfortable with that. And if we calculate the denial as July 18th, it was the first issue we addressed in our brief. 45 days from July 18th was Saturday, September 1st, and then you had Sunday, and then you had Monday was a legal holiday. We actually attached the court order saying it was a legal holiday, and that meant that we had to file by Tuesday, September 4th, and we cited the cases regarding the next business day. So
You say it's of no consequence. You can look at it as a deemed denial or an outright denial.
So
It's of
right,
no
if you
consequence.
look at it as a deemed denial, then you add 7 business days from the date of the request, and I don't know what the math is on that, but the county responded in 5 days.
Okay.
And then if you calculate it as a deemed
That works in your
denial,
favor if you
works
do
in
a
our
deemed
favor.
denial.
And then it puts it probably September, probably the end of that week, or maybe even the next week. So I don't have anything to add on that.
Okay.
Unless
Mr.
Your Honor has any
King?
other questions.
I do not. Mr. King, anything else?
Further, Judge, thank you.
Gentlemen, thank you so much. It was a pleasure.
Likewise, Judge, thank you.
That's all we have on the calendar today, guys.
See you the next.